Brent J Brant threw a water bottle at police officers and was subsequently convicted of felony harassment and third-degree assault. He appeals his conviction, arguing his right to counsel has been violated. The state had provided 4 separate lawyers to Mr. Brant, but after various threats and disagreements, they withdrew and Brant was left defending himself. Let's get it started.
I will give a short synopsis of each of the 4 cases before we begin the arguments. Our first case is a criminal case from Pasco, State of Washington versus Brent Brant. Mr. Brant was convicted of felony harassment and third-degree assault by reason of throwing a water bottle at police officers. The United States and the Washington State Constitutions grant a criminal defendant the right to an attorney to represent him or her during the criminal proceeding, including the trial. If the defendant cannot afford an attorney, the court will appoint an attorney at public expense. The right to an attorney may be forfeited by the defendant by particular behavior by the defendant, and that's what this appeal is about, whether or not the behavior of Mr. Brant led to a forfeiture. The Superior Court assigned Mr. Brant a number of attorneys, and after, I believe it was 4 attorneys, ruled that Mr. Brant had forfeited his right. On appeal, Mr. Brant asserts that his constitutional right to counsel was violated because of the failure of the Superior Court to assign new counsel to him and to warn him that his conduct might result in forfeiture of the right to an attorney. We will proceed with State versus Brant. Mr. Oliver Davis represents Mr. Brant on appeal. And on behalf of the state of Washington is Deputy Franklin County Prosecuting Attorney Frank Jennings. Mr. Davis, please proceed when you are ready. And how much time would you like to reserve for rebuttal?
May I reserve 3 minutes for rebuttal, Your Honor?
Please proceed.
Just a quick note before we start. After you spoke with the attorneys this morning, I was able to contact a colleague who's going to collect my belongings and materials from the case earlier this week. I'll be able to go straight to the airport from here, so I will be able to stay this morning.
Can you move the microphone a little closer to you? Just move it up. There you go. Perfect. Thank you.
Wonderful. We're glad to hear that.
My name is Oliver Davis, and I do represent Brent Brant. He was charged with third-degree assault for allegedly throwing water on a police officer. And he was charged with felony-level harassment for allegedly threatening to cause bodily injury to that officer. Now, normally a simple assault is only 4th-degree assault, and normally threatening injury to an individual is misdemeanor level harassment rather than felony harassment. Because of the important work that police officers do, each of these crimes was elevated to assault. In the case of the assault in the 3rd degree against a police officer, and harassment felony. And of course, harassment is, I suppose, a legal term of art that simply means threatening injury. I would like to very briefly touch on a couple of the errors that occurred at trial, because we believe that they also entitle Mr. Brant to have his convictions reversed and have a new trial. There may be some here this morning who are just now learning that Washington State not only has its own constitution, but that constitution in certain areas provides greater protection to the citizens of Washington than the United States Constitution does. And one of those protections that is expressly set forth in the state constitution is that judges should not comment on the evidence. And what that means is the judge shouldn't say anything to the jury in a trial, in a jury trial, that seems to express a belief by the judge as to what happened in the incident. Now, in this case, at the prosecutor's insistence, in addition to the standard definition of assault, roughly speaking, striking or hitting someone, the judge, again, at the state's insistence, told the jury that throwing water on a person is a striking. And that, unfortunately, to the lay jury, in other words, a jury that is not composed of 12 lawyers, thank goodness perhaps, that conveyed to the jury the judge's apparent, they certainly didn't intend to do this, but it conveyed to the jury the judge's apparent belief that Mr. Brant did throw water at a police officer.
Mr. Davis, let me ask you something. I know that the comment in the jury instruction is a little bit odd. I will agree with you there, but I'm not necessarily sure it's a comment on the evidence. If the prosecutor were to get up in closing argument and say throwing water on somebody is striking, would that be a prosecutor submitting their personal opinion on the evidence?
It would be a prosecutor arguing what the state believes occurred in the incident. But that was what was at issue, and it's for the jury to decide if Mr. Brant threw water on a police officer. He says he threw a water bottle towards the officers he felt were cornering him in an alley. The water bottle broke and water splashed on the pants of a police officer.
Well, and I agree with you on that distinction, but to say that generically or generally throwing water at a person is a striking seems to me more like a statement of law rather than a statement of fact. The judge didn't say this person threw the water or that the water struck the police officers. It just said generally throwing water is a striking.
I think that if the phrase throwing water had been inserted into the definition of assault as simply a couple of words included in the normal phrase, a punching is a striking of a person. Some cases have said, because the facts involved in that allegation, a punching or a spitting on somebody is an assault, to make the jury learn you don't actually have to contact a person with your body, but to pull that statement out and add it in addition to the definition of assault for the lay jury strongly suggested to the jury that it was already determined by the judge, and what the judge believed happened was that Mr. Brant threw water on the officer. That was strongly an issue. The question of Mr. Brant's right to counsel is obviously one in which he is greatly interested and the court is greatly interested. Mr. Brant does have a right to a lawyer. There were many, many hearings, as the court knows, on this issue, primarily because of the pandemic. The significant hearings and events at issue, I believe, are the hearing of January 5, 2021. That was when the court, for the final time, said, yes, I've given you several different attorneys. You don't appear to have been able to work with them. The attorney at the January 5th hearing said, Your Honor, Mr. Brant and I have had a very respectful relationship, but we have a very different view of what the strategy should be in this case. Therefore, I feel I need to withdraw. And for that juncture, within its discretion to do so, even though Mr. Brant had already received several different attorneys, the court said, you are entitled to another appointed attorney. And the court was pretty clear that it understood that there had been a developing problem with Mr. Brant's relationship with the Franklin County Office of Public Defense, to the point at which nobody in that office believed they could properly represent him. The court knew that, and the court's words were, that's their problem. They've got to find somebody, including somebody off panel, which might mean an attorney consulted and gathered from the bar in that area to represent Mr. Brant. So that was clear. And in the hearings that followed, however, probably because these hearings were held before many, many different judges. Somewhere along the line, the court believed that there had been a ruling in the case that Mr. Brant was no longer entitled to an attorney. And in those hearings, Mr. Brant was understandably very upset about that. And his upset was expressed in very strong language. He was deeply angry. And the court eventually decided to review the past history of the case and say, well, I've looked at what's gone before, and I don't think you're entitled to an attorney at all because of your behavior before this court. There are two problems with that. First, he'd never been appropriately warned that conduct could cause him to lose his right to an attorney. That topic was mentioned, but the crucial aspect of that warning is to tell the defendant there are a great deal of difficulties and disadvantages to representing yourself. When somebody asks to do so, to be their own lawyer, the court must be very careful to say, representing yourself is very difficult. I don't recommend that you do it. Here are all the reasons why it's hard. You don't know the law, etc. That same set of what we call threat of warnings has to be included in any warning to the defendant that he may be forced to represent himself if he engages in certain conduct. You can also lose your right to an attorney by more severe conduct than simply dilatory conduct. Severe conduct that is offensive and seems to be trying to just delay the case for that purpose. Well, two things. We know from Mr. Brant and from his attorney, Mr. Hill, that Mr. Brant wanted this case to be over with. He desperately wanted to go forward. He was sitting on the courthouse steps every single day, waiting for his attorney to come to the courtroom and represent him. And in addition, the anger and the upset that he expressed to the court was because of his belief that he was wrongly being denied an attorney. And indeed, the most recent ruling of the court was, I'm going to give you yet another attorney. The Office of Public Defense has got to go outside, off panel, and find somebody to represent you. And it's ultimately the court's responsibility.
Mr. Davis, doesn't this raise the issue of, obviously, an accused has a right to an attorney, but they don't have a right to an attorney of their own choosing. And isn't it possible that Mr. Brant, by his own choosing, is trying to dictate the attorney he's going to get? He allegedly, I guess it was a finding, that he was threatening towards his first two attorneys. He filed complaints with their office, with the Washington State Bar Association. He was given a new attorney. He subpoenaed that attorney to be a witness in some proceeding. He was assigned another attorney. That attorney was having a conflict with him. And then he was finally assigned Miss Bennett, who he refused to accept because she worked for the Franklin County Public Defender's Office. And then he also refused attorneys from Clear and Northwest Justice Project. So isn't it through his behavior possibly that he's limiting the scope of who can even represent him?
I believe the reason that Ms. Christine Bennett did not represent him after being appointed by the court is that Larry Ziegler from the Office of Public Defense says, I don't want anybody from this office representing Mr. Brant. And you're absolutely right, Your Honor, the defendant does not have a right to a free attorney of his choice. But in each instance, when a defendant says, I'm simply not happy with my appointed attorney, it is very much within the court's discretion to say, sorry, you've had 3 attorneys already. I'm not going to give you another one. But it was also within the court's discretion to say, yes, I see you want another attorney. I've looked at all the facts and I am going to order that a new attorney be appointed. And at that point, as the court recognized, the Office of Public Defense had to search far and wide if necessary to provide counsel.
So, Mr. Davis, let me ask you a couple of questions. Number one, part of your argument is that Mr. Brant wasn't warned that if he continued along this path, his right to an attorney would be waived or forfeited, correct?
Yes.
But the law is that under certain circumstances, a warning is not necessary.
Yes.
And one of those circumstances is threatening behavior towards your attorney, correct?
Yes, but the threatening behavior that contrary to the written findings of fact of Judge Swanberg, and we've challenged a number of those findings, the notion that Mr. Brant threatened his attorney was something that happened with his first attorneys 2 years ago. And
Okay.
it was not something that happened at any recent time. And every court that appointed a new attorney already had that information. That problem was ancient.
Mr. Davis, your time has expired. I ask that you complete your answer to Judge Staab's question.
So I think, Your Honor, that once Mr. Brant the court ordered that Mr. Brant be given yet another attorney within the court's discretion to do. There was no threatening of any attorney after that juncture. And indeed, the threats that were alleged to have occurred in the past were very much in the past. 2 years earlier, every attorney after that said, we're working where he's respectful with me, but we just disagree on the law. I think he needs new counsel. So violence or threats were not a basis to find that he forfeited his right to an attorney, the most severe document. Thank you.
Thank you, Mr. Davis. You will have 2 minutes for rebuttal. Mr. Jenny.
Good morning, Your Honors. May it please the court, counsel, Frank Jenny with the Franklin County Prosecutor's Office, representing the respondent state of Washington in this case. Your Honors, Brent Brant, through his conduct, could be compared to a military commander whose first mission was to destroy his own base camp. He repeatedly worked against the Franklin County Office of Public Defense, which was there to assist him in working through the process, whether it be through a trial or through resolving the case short of trial. There are people who are there to help Mr. Brant in that situation. Instead of working with his attorney, he found every possible way to obstruct the system. You know, when Clarence Earl Gideon fought for the right to have counsel appointed at public expense, he realized he was fighting for something of value. And anyone who's read Gideon's Trumpet knows that once he finally got a lawyer to assist him, he did everything he could to work with his lawyer to take care of the case. Brent Brant failed to live up to that tradition. He obstructed his attorney at every opportunity he had. Your Honors, the case that's factually closest to this of those that are cited in the briefing is the United States versus Thomas. 357 Fed Second 357. 357 is both the volume number and the page number. And that case has been cited with approval by this case and was cited by the Franklin County Superior Court in the order finding that there had been a forfeiture of counsel. In that case, the Third Circuit stated, with respect to forfeiture, Thomas argues that the district court erred in finding that he threatened his attorney, engaged in his extremely serious misconduct. The district court did not err, including the Thomas's statement that Thomas and McClellan, the attorney, should stop yelling at each other or else they could become involved in a physical confrontation constituted a threat. Moreover, the district court did not rely solely on Thomas's threats in finding forfeiture. Indeed, the district court also emphasized that Thomas had been verbally abusive to his attorney, tore up correspondence, and refused to cooperate in producing the witness list. He had hung up during a telephone conversation. He attempted to force his attorney to file several meritless, frivolous claims. And moreover, perhaps most importantly, the district court found Thomas had forfeited the right to counsel because he had engaged in the same misconduct not once, but with respect to 4 different attorneys. Your Honors, that's precisely the situation we have here. Every attorney that was assigned to Mr. Brant experienced problems with him. The problems ran the gamut from threats that caused one attorney to fear for her family's safety, to failing to cooperate with counsel, to insisting the counsel engage in unethical conduct by filing frivolous motions.
Mr. Jenny,
Yes, sir.
can I ask you a question? Do you agree with Mr. Davis's statement that Mr. Brant was not warned that his continued conduct would result in him waiving or forfeiting his right to an attorney?
2 points on that. Number one, first of all, that very early on in the process, Judge Ekstrom did warn him exactly that.
Is it in the record?
It is in the record and is quoted in our briefing.
Okay.
That was very early in the process. Secondly, there are three different concepts here. One is the one of waiver. Waivers of knowing, intentional, voluntary relinquishment of a known right or privilege. That requires the Faretta warnings that Mr. Davis made reference to. At the other extreme from waiver, it is forfeiture of the right to counsel. For forfeiture, there does not have to be any warnings whatsoever. It can be strictly through the defendant's misconduct, whether it be serious misconduct of poor counsel or other serious misconduct toward the court or extremely dilatory conduct. Those things can result in forfeiture of conduct, the forfeiture of the right to counsel. Forfeiture does not require that there be any prior warnings for that to occur. Now, there's also an intermediate concept, one of a waiver by conduct. Now, that's where the defendant is warned that any future misconduct will result in waiver. And then if the defendant then proceeds to engage in that same type of misconduct, then that would be found to be an implied waiver of the right to counsel. Now, certainly in this case, with the warnings that Judge Ekstrom gave early in the process, we could certainly find that there was a waiver by conduct. That's not what the court found. The court found that there was a forfeiture. And so we really don't have to go any further than that than to conclude that there was in fact a forfeiture. For a forfeiture, there does not have to be any warnings whatsoever. That is simply not a requirement. In extremely serious misconduct, the court can find that there has been a forfeiture of the right to counsel. And again, that does not require any prior warnings.
Mr. Jenny,
Yes, right.
Franklin County operates the Franklin Office of Public Defense, correct?
That is correct.
Which is led by Mr. Ziegler,
Yes.
correct? Let's assume that the office, because of a conflict or for some other reason, cannot represent a defendant, that no counsel within that office can represent the defendant. Is there other counsel available?
Your Honor, there is, and the court does have authority under the statute to appoint outside counsel. And if there is a conflict, the court can appoint outside counsel. Mr. Ziegler does have other attorneys that have contracts elsewhere that he has in effect on a standby basis where he can make arrangements with those individuals to represent defendants. And certainly there are situations where it is necessary to go off the public defense panel and appoint someone who's not one of the regular public defenders.
Was that process explored in this case?
Here's what happened. After the defendant succeeded in disqualifying the entire Office of Public Defense.
By reason of filing a lawsuit
By
against it.
filing a lawsuit and going through every attorney.
And you claim that conflicted out all of the attorneys in the office, correct?
Well, it's not what I'm claiming. That's what Mr. Ziegler concluded, that it was impossible for his office to work with Mr. Brant as a result of the federal lawsuit that had been filed. That was not the only basis for concluding that, however. Mr.
Okay, well, I interrupted you. If
Sure.
you answer my initial question,
Very well.
maybe I need to ask it again.
Certainly.
Was the process of exploring counsel outside of the Office of Public Defense explored at some point during Mr. Brant's proceeding?
It was explored, but what the court concluded was that Mr. Brant had forfeited the right to counsel. After he had gone through every attorney on the panel, at that point, the court concluded that he had.
Maybe that was error. Maybe there could have been a difference if we went outside the office.
There has to be an end to this process somewhere. At some point, the court has to conclude that the defendant has forfeited the right to counsel. That's what occurred here. After he'd gone through every attorney on the panel and disqualified the entire Office of Public Defense, the court concluded that there had been a forfeiture of counsel. Now, as far as appointing an attorney outside the panel, two problems with that. Number one, this court has ruled in interpreting statute that when outside counsel is appointed, that attorney must be compensated in such a way as to assure the financial survival of the attorney's law practice. Now, in that situation, the taxpayers will have already funded an Office of Public Defense. If an outside counsel is appointed, that places an additional burden on the taxpayers. If that were the rule, that they always had to go to some outside counsel after the entire Office of Public Defense was disqualified, defendants would only need to find some way to disqualify the Office of Public Defense and then be in a position where they could force an additional burden on the taxpayers.
Mr. Jenny,
yes,
I'd
ma'am.
agree with you that defendants shouldn't be allowed to manipulate the system.
Yes,
One of the problems that I have in this case is that Judge Swanberg went through and made findings on what Mr. Brant did, but he did not find that he was doing these things for the purpose of delaying or manipulating the system.
all right. It's not necessary that it be done for purposes of delay. That's one of the ways that a forfeiture can occur, but that's not necessary that it be for that purpose or for any purpose of that nature. It can also be found through abusive conduct toward a counsel. And I mentioned the United States versus Thomas, and very similar facts. There, the defendant went through 4 attorneys and was engaged in abusive conduct toward all of them, making threats, insisting the attorney engage in unethical conduct. And that was found to be a forfeiture of the right to counsel. Precisely the situation we have here, if the court finds a serious misconduct, that is the basis to conclude there's been a forfeiture of the right to counsel. It is not necessary that the court find that there be any particular motive for the defendant. It is based on the conduct of the defendant, not on the motives of the defendant or any intent on the defendant's part. So certainly that's all that was necessary here. Mr. Brant went through the entire panel, he disqualified the entire Office of Public Defense, and he made no secret of the fact that it was his objective to disqualify the entire Office of the Public Defense. Repeatedly, he stated to the court, I filed this federal lawsuit. I can't be represented by the Office of Public Defense. I can't be represented by the Northwest Justice Project, as Your Honor mentioned. I can't have anyone from Clear is a hotline for low-income persons to obtain legal assistance. He was simply in a situation where he was insisting on who was going to represent him, and he didn't want to hear anything different from the court. Judge Fearon remembers Judge Al Yankapol. Early in my career, I was doing some public defense work, and one of my clients was complaining to the court about me for some reason, and Judge Yankapol said, "Well, you want Melvin Belli?" I mean, that's the way Mr. Brant was. He just wasn't satisfied with anyone who was going to represent him. And he literally went through the entire panel. And one thing that Mr. Ziegler and Mr. Brant agreed upon is that Mr. Brant had made it impossible for anyone from the Office of Public Defense to represent him. Mr. Ziegler concluded that, and that's exactly what Mr. Brant said too. If he didn't disqualify the entire Office of Public Defense, it was invited error, because Mr. Brant repeatedly told the court that no one from the Office of Public Defense could represent him. Having engaged in that type of misconduct, the court properly, under the line of cases that's discussed in the briefing, concluded there had been a forfeiture, and consequently, there was no error whatsoever in the court by the court's part in reaching that conclusion. Might also mention the comment on the evidence issue. It's not a comment on the evidence unless the court resolves a factual issue. Here, the court did not resolve a factual issue. It simply defined the crime of which the defendant was accused. The court made clear that an assault is an intentional striking of another person that a reasonable person would find harmful or offensive. The court did instruct the jury that throwing water on a person constitutes a striking. You know, an average layperson might just assume when they think of a striking, they think of hitting someone with a closed fist. The court made clear that was not necessary, that throwing water would constitute a striking.
Mr. Jenny,
Yes, Your Honor.
I'm confused as to what was thrown at the law enforcement officers. I thought it was a bottle of water rather than a spray of water. What, did water come out of the bottle?
It did.
Okay, and did the bottle hit one of the officers?
I'm not positive it actually hit one of the officers, but it splashed water on them. He threw the water bottle and then splashed water on the officers. Now, the jury then would have to find that he intentionally splashed water on the officers. And so Mr. Brant was certainly free to argue his theory of the case. So there is no issue whatsoever there about the instruction actually resolving a factual issue. It did not resolve a factual issue, but enabled him to argue his theory of the case.
Thank you, Mr. Jenny.
Thank you, Your Honor.
And Mr. Davis, you have 2 minutes for rebuttal.
Thank you, Your Honor. I did not have a chance to mention it in my opening. I don't want to be unfair to Mr. Jenny, but we of course do have the issue of the trial court going beyond what was necessary to explain to the potential jurors why Mr. Brant had lost his right to attorney. The court was certainly entitled to tell the jury he had lost that right by conduct. We of course disagree with that premise in the primary part of the brief.
So,
The
Mr.
court did
Davis,
not have said-
let me ask you a question then, sir, because that was an interesting issue. The court issued an order in limine saying, don't talk about this. And Mr. Brant just ignored it and violated that order, blew right past it. And so the court felt, since he was attempting to basically poison the jury against the state, that in order to make a fair trial, the court had to try and balance that out. And I'm assuming that's why the court read that finding into the record to try and create that balance. What should the court have done?
The court could have created that balance by telling the jury, Mr. Brant lost his right to an attorney by virtue of conduct that merits loss of that right. If Mr.
But then Mr. Brant, I mean, I think he said, no, I didn't, that, you know, the state is corrupt, the government's corrupt, and blah, 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 blah.
And he could have been held in contempt for that outside the presence of the jury, but to tell the jury that he had lost that right by violently threatening his attorneys, which by the way, we signed errors that occurred 2 years previously, the court went well beyond what was necessary to explain to the jury that the loss of an attorney was correct and inform the jury that the defendant was violent, allegedly, in a case where he was charged with violence.
Mr. Davis, it looks like the judge first warned or explained to the jury that he forfeited his right to counsel. And that was the end of it. And then when Mr. Brant spoke up and started challenging that, that's when he read the order.
Yes.
What other alternatives would the judge have?
I think contempt, and I certainly concede, a very difficult situation for the trial court, as is often the case with pro se attorneys. But to go beyond telling the jury that it has been ruled that he has validly lost his right to an attorney by conduct, to go beyond that and mention violence wasn't necessary and was particularly harmful in a case where he's charged with violence, we believe was an irregularity in itself.
Your time has expired, Mr. Davis. Any further questions for Mr. Davis? Okay, thank you, Mr. Davis. The case of State of Washington versus Brant is submitted. Thank you to both counsel.
Following these arguments, the court disagreed with Mr. Brant and affirms the trial court's decision. Mr. Brant's threats and refusal to cooperate with counsel resulted in his forfeiture of his right to counsel. And there you have it, folks. If you like this video, please like and subscribe for more Court of Appeals next week.